Well, good afternoon, everyone. Thank you so much for joining us for um, another educational presentation, this time on estate planning essentials. We've done a lot of various topics over the years covering investments to healthcare, retirement, tax planning, and we really felt like it was a great time to reintroduce the concept of estate planning to clients. And um, I have Debbie Makowski joining me. She's an advanced planning attorney from the Hargrove firm. Really excited to have her and her wealth of knowledge and experience that she's going to be sharing with us today. Uh, I am going to, wrap things up with a summary of how we partner with NetLaw and the Hargrove firm to streamline the estate planning process and simplify what can be a difficult and an exhausting topic for clients. So before we jump in and I give the floor to Debbie, I wanted to just read through a quick disclaimer. So the content that we're going to be covering today is for informational purposes only and does not constitute legal advice. It's not intended to be relied upon as legal advice. And for any advice pertaining to your specific situation, please consult with a qualified legal professional. And we'll cover how to do that at the end of the presentation today. So, Becky, the floor is yours.
All right. Well, thank you, Adam. Welcome, everyone. Good afternoon. As Adam mentioned, my name is Debbie Makowski, and I am an advanced estate planning attorney here at the Hargrove firm. And would just like to welcome you to the webinar. We work closely with the Burney company. And for today's agenda, what we would like to do is review the basics of estate planning, so you have a basic understanding to learn the fundamental concepts and importance of estate planning. I will review some of the key documents and roles of those documents, and that will include trust, wills, powers of attorney, your healthcare documents, and healthcare advance directives. And we would also like to touch upon the advantages of trust-based planning, so you can discover the benefits of trust-based planning and why it may be the right choice for you. So understanding the basics of estate planning. Estate planning involves making decisions about who will receive your assets and who will make decisions regarding healthcare decisions and financial decisions if you are unable to do so. So we want to make sure your wishes are followed regarding all of your asset distribution and also any healthcare decisions that you may have. So some of those key considerations when we talk about asset distributions with your estate, we want to determine who gets what, when, and how, and really in the most cost-effective and efficient manner. Healthcare decisions obviously outline your medical preferences. It could be end-of-life decisions. Anything regarding healthcare, it is critically important to make sure you have that in writing with the appropriate documents. So who needs an estate plan? Really, everyone should have an estate plan to control what happens to their property, either when they die, when they pass away, or in the event someone becomes incapacitated. The main reasons to have an estate plan are to avoid family disputes, preserving your assets for loved ones, also providing for minors through a guardianship document or any individuals with special needs through a special needs trust, minimizing taxes and administrative cost. And when you have an estate plan, it also makes it more efficient and cost effective for your loved ones. So here at the Hargrove firm, we are always trying to find ways of how do we preserve your estate? How do we make things easier for you and your loved ones? So basically, everyone should have an estate plan so things are directed as you desire. The main concerns of estate planning, people are wanting to maintain control and autonomy over their decisions for as long as possible. Another consideration is to minimize taxes and to maximize that wealth transfer to your loved ones. And as we kind of mentioned before, people want to make things easier on their loved ones. And when you have that estate plan in place, it is simplifying the whole process for those that are taking over your estate upon your demise. We're now going to review some of the key documents and the roles those documents play. So, starting with the living will, that is a document that can specify your healthcare preferences. If you become incapacitated, all states are different, and the living will really upholds your preferences. So, when you appoint an agent with your living will, they are there to honor and respect the decisions that you make. It really does guide the healthcare providers and your loved ones so they know what your wishes are when it comes to healthcare. Another document is the healthcare surrogate designation, and that is where you designate an individual, or you can have multiple agents kind of listed in sequential order who can make healthcare decisions on your behalf if you are unable to do so. This is much broader than the living will. Hospitals, nursing homes, assisted living facilities, they all like to see the healthcare surrogate designation. These documents are called different things in different states. And I just wanted to review that the Hargrove firm, we are national in scope. And so we work with clients in every state. So if you see these terms and maybe it's called something different in your state, that is perfectly fine. As I mentioned, we are national in scope, working with clients in every state. We have of counsel relationships with attorneys in every state. So when you do work with our firm, everything is customized appropriately for the state in which you reside. The next document is that HIPAA authorization, and this is a very important document where you appoint an agent, and then we list multiple agents, and it allows that agent to have permission to your healthcare records. A healthcare provider can disclose that medical information to the designated individuals, so your agents actually have access to medical records so they can make an appropriate decision if needed. That is a very important document. HIPAA is very stringent and tight, and without that document, there isn't a release of medical information. So those are some of the key documents that surround healthcare and are very important for everyone to have. Next document is a power of attorney for finance. Sometimes it's called a general durable power of attorney. And this is a legal document that is going to grant someone the authority to act on your behalf for financial and legal matters. So this can be used in the event a person is unable due to incapacitation, they're incompetent, or you can have it where, let's say you're out of the country traveling, you need someone to pay your bills, make financial decisions, handle a legal matter for you. Your agent can certainly do that. So that designated agent, obviously someone that you trust, but they can handle your financial transactions and legal decisions. These documents, when you work with a Hargrove firm and the Burney company, they're all included in your estate planning. So I wanted to dive more into actual estate planning for the estate. There is trust-based planning versus will-based planning. And we're really going to focus today on trust and how that pour over will can help you. But while everyone's situation is different, trust-based planning offers some really key advantages. First and foremost, it avoids probate court. When you set up a revocable living trust and the proper assets are transferred to it, probate avoidance occurs. Why is that important? I mean, probate is a very important court. However, when a will passes through or an estate passes through probate, you're really subject to the terms and conditions of probate court. So it can take unnecessary time and delays. So the trust avoids having to go through the court process. A trust is also a private document, which is very important for many people. So you do retain privacy with a trust, and you have flexibility and control with a trust. So the flexibility kind of comes into play of how we do our drafting here at the Hargrove firm, making sure that your trust represents your wishes and it is completely customized for your family needs. And it also keeps you in control. So most of our clients, they are the initial trustee of their trust, so they are in control of their estate during their lifetime. Some of the key documents and rules of the trust. So, a trust is a contractual agreement. It allows a third party or yourself as trustee to manage those assets and eventually have them distributed to the beneficiaries. We kind of talked about the purpose, providing flexibility in managing and distributing your assets according to your wishes. We are all about efficiency and cost effectiveness. So a trust is just a much more efficient vehicle to transfer those assets to your loved ones. And of course, the role of the trustee manages the trust. So typically that is a client during their lifetime. And then once that successor trustee is appointed, they are in charge of distributing the assets. They do have a fiduciary responsibility to follow the terms of the trust. As far as types of trust, there are a couple of types. There's the revocable, which is completely changeable during your lifetime, and the irrevocable. That serves a very different purpose, as sometimes there are special needs trust or an irrevocable life insurance trust. We run the full spectrum, so our law firm focuses in estate planning, business planning, tax planning. We run the full spectrum of estate planning tools, and we generally use the revocable trust at the beginning, and in more advanced planning or special needs or that irrevocable life insurance trust, we can always incorporate that into more advanced planning if needed. Types of trust, separate or joint, and that really depends on, are you living in a community property state or not? We evaluate that on your behalf and give you our recommendations. One thing I wanted to touch upon is the importance of funding the trust. This is critically important to accomplish that goal of avoiding probate. A funded trust simply means you're retitling assets, transferring deeds, any asset that we know should be actually retitled into the name of the trust. We assist in that process. Sometimes your trust is named as the contingent beneficiary of an asset, such as a retirement account. We work directly with the Burney company. They are an esteemed partner of ours, and we work directly with them regarding any of the funding of the assets you have under management with the Burney company. But our firm really takes funding in a very serious way, because we know that's what makes the trust come alive. That's what makes everything work, is when it is properly funded. And then I mentioned the last will and testament. So it's not contradictory with the trust. If you create a revocable living trust, our firm also drafts a pour-over will. And what that is, it's a legal document, and there are terms in that document to make sure your assets are distributed upon your death, but it really is a safety net. The purpose of that pour-over will is to ensure any assets that were accidentally left out of trust or your residuary estate are distributed according to your wishes. And from a practical matter, how it works is that pour-over will is presented to the probate court, letting the court know this client has a trust. They did not transfer an asset to it. So this safety net picks it up out of probate and pours it over into the trust. So we always include it as a safety net. It is very rarely used, but your executor of your last will and testament is the same person you're appointing as the successor trustee of your trust. So like I mentioned, it's not used often because we ensure that your assets are properly transferred to your revocable living trust. All right, moving along. For those who have minor children or a child who may possibly need a guardianship, we include that guardianship designation right inside of your pour-over will. And that is going to specify who would care for your minor child if both parents are deceased. That is care over the person and the property of your minor child. And for an adult child who may have special needs, a guardianship can also get appointed over that child. The purpose is to ensure that your children are cared for by someone you know and trust. And as I mentioned, the guardian is responsible for not only the personal well being of a child, but also the financial well being. So, guardianship designations are very important and they are included right in that pour over will. So just to kind of go through a little bit of understanding probate, it is a legal process and it is a way to administer a deceased person's estate. All wills are state specific, and all those laws, which is set in distribution, and the process and the time frame are very state specific. But probate is going to verify the will. You have to do an inventory of all the property, payment of debts and taxes, and distribution of the remaining property. Probably the worst thing about it is just the statutory restrictions. So everything is according to the court's timeline. I kind of use the example, if a home is in probate, and let's say it takes 9 months or a year for the estate to get out of probate. Sometimes real estate is sitting, not a whole lot can happen to it. It can't be sold during that time frame. So it's really an unnecessary delay of time. And so that's why we focus so much on trust-based planning. We do not want an estate to go through this if you can plan otherwise. So, as far as working with a Hargrove firm, as I mentioned, we work directly with Burney Wealth Management and their clients in order to work with us. Adam, if you'd like, I can certainly hand it over to you. You can review how to work with our firm. I can chime in if you need any answers.
Sure, Debbie, thanks. And just for some general context, when we're speaking with clients and working with clients, we usually hit two big hurdles when it comes to estate planning and having clients update their estate planning documents. One is the idea of thinking about your estate and your passing and the family dynamics is typically a difficult conversation to have, and people, it's easy to put off and avoid. And the second piece is the idea of, working through attorneys' offices and the scheduling and the logistical gymnastics that come with traditional estate plan updating is, it feels like a lot of work, and it's easy to push that off in a lot of circumstances. So, for us, it was really about how do we find a process that's convenient but still has a human element to it. There's a lot of tools now that involve doing your estate plan 100% digitally, and you get a password to something and you log in, but you don't really have that guidance and that Q&A and handholding from an attorney as you're thinking things through. So what we really enjoy about working with the Hargrove firm through NetLaw and the process that we're excited to be able to introduce to our clients in the right circumstances involves, really a meeting of the best of both worlds, where there's a digital element and a process that's streamlined and electronic and allows clients to handle a lot of the heavy lifting um, without, a lot of running around and extra work outside of the house, but also having that FaceTime with an attorney and a legal team along with your advisor at our firm, to create that team approach with the least amount of work possible. Because, Debbie, as you emphasized, a lot of this is really important, and it's the thinking through of the distribution of your estate, but it's also making sure things are funded appropriately and making sure that things actually get done from point A to B. So, for us, that's what's really exciting and why we're now encouraging clients, especially in lieu of the estate exemption amounts potentially reverting back at the end of next year. It's a great time to revisit this and have this conversation. And this is something where if you go directly through your advisor on the Burney team, we can make the introduction and start the process and help with our knowledge of you and the client situation. We can contribute a lot to make things easier. So hopefully I didn't miss anything with that, Debbie.
No, no, that was wonderful. And just to mention, the Hargrove firm, as I talked about, we are a national law firm, And we focus in estate planning, business planning, and tax. And then NetLaw is our sister company. It was founded about 12 years ago by Jamie Hargrove, the founder of the firm. And what's wonderful about NetLaw is it is the technology that powers the Hargrove firm. That's what allows us to provide things efficiently and effectively for our clients. So NetLaw streamlines that intake process. So when you go into NetLaw and enter your information, I review it 3 days prior to our consultation. So we have an hour consultation together, and that's when we dive deep into those topics and your answers in NetLaw. I can answer questions you may have, but that is like the framework for your basics of estate planning. And then NetLaw is, like I said, that technology component. So everything delivered by the Hargrove firm is customized, so your wishes are represented. All of your documents are completely customized. We make sure we have the proper provisions in when it comes to beneficiary designations. That is critically important. So it is comprehensive in nature. And as Adam mentioned, getting you to the finish line. And I always say that finish line is when funding has occurred. So having the documents are great, but if things are not funded in it, it really undermines the whole process. So really the Hargrove firm is with you every step of the way to make sure, one, your estate planning represents your wishes, and two, we have completed it in its entirety.
All great points. Thanks so much, Debbie. Yeah, we typically either see documents that have been written but not signed, documents that have been drafted, but the proper funding and titling changes and beneficiary designations haven't been updated, or life circumstances have changed dramatically since the last time estate documents were drafted. So this is an incredibly important part of the overall planning process and the management of your wealth. And again, our job is to help clients get through the process in the most efficient way possible. So we're excited to be able to make this introduction and work with you and Debbie and her team to hopefully make things as convenient and streamlined as possible. So we appreciate all of the great information and background you shared, Debbie, and we've got a lot to discuss with our clients. And if anyone has any questions or wants to take this conversation down a more personalized path with their advisor, reach out to your point of contact on the Burney team. We'll kick things off, and then we'll help make an introduction to Debbie and the Hargrove firm so that we can make things are buttoned up, make sure things are buttoned up and updated for everybody. So appreciate everyone's time. Any questions, route them through us. This will be recorded. In the event you need to revisit this at a later date, but we appreciate everyone and hope you enjoy the rest of your week.